Hey, Casey.
Hey, how you doing?
Doing well, my friend.
When they say no, we're just going to invite out of county.
All right, court calls cause number CR 21371, State of Texas versus Casey Lynn Spriggs. Mr. Ashmore, I think we're set today on status on the cell phone discovery.
Yes, Judge. Just quick update, and thank you, Your Honor, State, for allowing me to, no objection to me having to appear by Zoom. I visited with Mr. Spriggs this weekend. He is aware that we have had this ongoing request. Been in touch with both the state of Texas, Mr. Woodwike, with Deputy McLeish, with the Van Zandt County Sheriff's Office regarding the search for these cell phones that we understand were turned over to an investigator at some point. Mr. Woodwike has communicated with me, Deputy McLeish has communicated with me that they don't have a chain of custody log with regards to these cell phones, and that they have looked for them diligently and cannot find them. I understand that there is a piece of documentation that will be produced at some point from Mr. Woodwike or the state regarding their efforts to comply with the Michael Morton Act, Chapter 39.14, regarding discovery requests. But that as far as they have flipped over the rocks and they cannot find these 3 Android cellular telephones, smartphones.
State.
Judge, that's correct in most parts. The state has already turned over to Mr. Ashmore. The DA investigator performed an independent investigation, contacted Mr. Spriggs' mother, who did tell my investigator that she believes she turned them over to someone in the sheriff's lobby, but didn't get a name, didn't get a receipt. To anything like that. We do not yet have a report from the sheriff's office regarding their investigation into figuring out if they have them. I will get with Deputy McLeish and get some sort of report as to her due diligence in trying to locate these cell phones. I will just note that Miss Spriggs, the defendant's mother, cannot tell us what kind of phones, brands, makes, models, serial numbers, anything. So the sheriff's office doesn't really have a lot to go on to find these, but they have looked through all of their records. They can't find any chain of custody regarding Mr. Spriggs or Mrs. Spriggs turning over any phones. But we will get the documentation to Mr. Ashmore regarding the sheriff's department, but he does already have my investigators report into our attempts to locate these and our compliance with the Michael Morton and Brady requirements that are on this office.
All right, thank you, Mr. White. So, Mr. Ashmore, do we have any other pretrial issues that would prevent us from moving the case to a docket call?
Only that we have not yet, even though we have a signed order and relief granted on a mitigation expert and funds for a mitigation expert, we have not been able to get a mitigation expert sourced that has the bandwidth. I've contacted the Texas Criminal Defense Lawyers Association, Jennifer Brashear with the Andrews Center, my old friends down in Austin, Texas, and to try to source a person with the qualifications that we presented to court and the order that the court signed. And as of yet, still have not been able to find that. I think once we get that person engaged, it will be very quickly that they can get that scope of work done. And I don't know if it's just the busyness of all of the counties opening up for jury trials or what, but I've had literally no contact back from my request. It just, there's not a lot of folks with this kind of qualification, and the ones that have it just don't have bandwidth. That's the only reason that we're not ready in all other respects. So I'd ask for some time on that, simply because that's not as easy a resource to tap into, find, and get on board on this case as maybe it was a year or 2 or 3 years ago.
Okay. I want you to give me a self-imposed deadline.
I'd ask for 90 days till today's almost the end of March. So April, May, June, beginning of July would be my request. I think if we can't find somebody in 90 days, we'll be ready to talk to the court about the next step moving forward. But it's been 90 days, not even 90 days, since you signed the order and heard that request for relief. And we've literally had just, sorry, don't have time, can't get to this. It's I won't say the door's been closed in our face. It's open. It's just, we don't have time for this right now, or no reply back because they're so covered up.
State, any position?
State takes no position on defense's request, Judge.
Mr. Ashmore, are you available on Tuesday, July 11th?
I'm looking right now, Judge. I'm going to switch. It might shut the camera off. Yes,
You're available on July 11th.
yes, sir. I just checked the calendar. It's open, and I'm going to mark it down for this matter.
Okay. Court sets Casey Lynn Spriggs for a final pretrial hearing, CR 21-371, on July 11th, 2023 at 1:30 p.m.
Yes, sir.
All right, is that all you have, Mr. Ashmore?
It is. Thank you so much, Judge.
All right, thanks, sir. Have a good day. Thank you, Mr.
Okay,
Spriggs.
Casey, I'll see you soon. Thank you, Judge. Thank you, Tyler.
All right, who do we have that's ready? Anyone else? Mr. Barron, you ready?
Yes, Ron, good afternoon. I'm Mr. Kobe Herod, is felony information violation, Your Honor, CR 18-00263. He also has an adjoining misdemeanor, which I believe this court now has jurisdiction over. It's 2020-00379, Your Honor. We have an agreement with the state on the probation violation, both on the felony and misdemeanor. And would ask Your Honor if we may set it for plea on April 4th at 1:30 next week. I spoke to Tyler, he's amenable, which I paid, so that would be great, Your Honor.
Okay, very well. Court will set Mr. Heron to enter his plea on April 4th at 1:30 p.m. And then so fill out that notice of appearance, give Mr. Heron the yellow copy, and then we'll see y'all back on April 4th.
Thank you so much, Your Honor.
You're welcome. Do we have any other counsel ready?
Judge, on Brian Collier,
I think I'm ready, but he's in Henderson County and I don't know if y'all are anticipating zooming him or not, but
At 2 p.m. Yeah, I think they're going to both, the Henderson County inmates will be zoomed in at 2 is what we were
guys, thank you.
told. Mr. Schmidt, are you ready on Zakori and Fulbright at all?
No, they haven't brought him in yet, Jeff.
Okay, all right. So I'm assuming that none of your other clients were there.
That's correct.
Okay. Is Michael Shane Cubby in the courtroom?
And you guys are covered.
All right. Thank you.
Using his connections. What? He's just using his connections. Yeah. I feel like those are better used. I agree.
Mr. Manning, you ready?
Yes, Judge.
Who are you ready on, sir?
Judge, I have Mr. Murphy here. They pulled him. My understanding was that the dismissal had been signed. I think I got a copy of that. So I was unsure if there was anything else that that's not on the docket that he was being held on through Van Zandt County.
And I'm sorry, did you say that the state dismissed this case, CR 22-153?
Yes,
Judge,
Judge.
the court signed the dismissal on Tuesday.
So you're asking me if the sheriff's office is holding him on something else?
I just didn't know if there was possibility there was another hold or case of the DA's office that we didn't have resolved that would possibly be a hold.
Let me take a look, Mr. Manning. The DA's office has no records of any other charges pending against Mr. Murphy here, and I don't see that he's being held on anything other than the case that was dismissed on Tuesday.
I'll check with the jail after court today and see why he's still being held.
Mr. Manning, if I can be of assistance on that, let me know.
I appreciate it.
Let me check here, Mr. Manning, to make sure that this dismissal has gone through the clerk's office, been filed and sent to the sheriff's office.
Yes, Judge.
You show that the order dismissing the case was file marked on Tuesday at 11:23. So
I will speak to the jail staff and see if we can figure out what went wrong there.
all right, thank you, Mr. Reno.
Yes, Judge. I'm also to Mr. Pogue.
Mason Gregory Pogue at CR 2276. Will this be a plea today?
Yes, Judge, we're gonna actually have, the state's gonna withdraw and amend the conditions for his participation in Senacor. He signed the amendment to those probation conditions. And I also have the state's motion to withdraw and continue.
And this is approved by probation. Senacor has been specifically approved by the probation department.
Yes, sir.
Okay. All right, and so that paperwork's being drawn up, Mr. Manning, is that what you said?
I'm sorry, Judge.
You said that paperwork's being drawn up?
It already is completed, Judge.
Okay. All right, Mr. Pogue, raise your right hand. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. Your name is Mason Gregory Pogue. Mr. Pogue, you're on this court's community supervision, and a motion to revoke has been filed, and Mr. Manning has been appointed to represent you. Do you feel like you've had enough time to talk with him about your motion?
Yes, sir.
And Mr. Manning has indicated to the court today that you want to amend your community supervision to include a drug treatment at the Senacor placement. And you're telling me that you are intentionally, knowingly, and voluntarily agreeing to the amendment of your conditions. Is that correct?
Sir.
Has anybody threatened, forced, or pressured you to make you feel like you had to amend your conditions of community supervision?
No, sir.
Mr. Manning, you've explained the motion to revoke to your client. You believe that he is competent today to enter into this agreement,
He is, Judge.
and he understands what the amendment will result in.
He does understand that. The one question he had is his bed is not available until Monday. And it says for him to turn himself into the program at the recommendation and time of his supervision officer's request. So we just request that be set for Monday when his bed's available at Senacor.
You're asking me to tell the probation department when to set it, or y'all, what is y'all's agreement on when he goes in?
Judge, it's not listed in this document. I just was able to review it, and it just says to follow recommendations and to participate when notified by his or her adult supervision officer. We just ask that they be aware that our understanding is the bed's not available till Monday.
All right, so the court's going to order you, Mr. Pogue, to report to the Senacor program on Monday of next week, which should be what is that, April 3rd? And so you'll report to Senacor on that date unless you are contacted by your probation officer before changing that date. Do you understand?
Sir.
And your failure to abide by that is going to be a violation of your conditions of community supervision. Do you understand that?
Yes, sir.
Okay. All right. The court's going to grant the state's motion to withdraw and the motion to amend to include placement at the Senacor program. So, Mr. Pogue, you'll sign your amendment to your condition and then follow the directions of your probation officer. Okay. Mr. Manning, do you have anyone else that you're ready on?
Judge, not at this time. I have a couple others in progress.
Okay. Just let me know when you're ready.
Thank you, Judge. I don't need to.
Judge, we have Mr. Whitaker that's ready.
You good? Okay. Back to jail. No alcohol, no water. In court. Yeah, no process, whatever.
Yes.
All right, Mr. Wells, you said that you are ready on Whitaker.
We are, Judge.
All right, come on up, Mr. Whitaker. Court calls cause number CR 23-34, CR 23-35, CR 23-36, State versus Jeremy David Whitaker. And will this be a plea on each case, Mr. Wells, or will there be any 1245s or dismissals?
So there'd be a plea, Judge, to 34 and 35. There's a 1245 on 36. And then we also have a revocation on his misdemeanor if the court would entertain that.
Is that one that's in my court or is that in Judge Winter's court?
It was actually out of Judge Winter's court.
Okay, so unless it's in my court or he's given permission, I would rather him sign that.
You want me to deal with it just in his court on the next docket?
That or transfer it up later and that revocation we can, is it going to be a dismissal or is it going to be a conviction on the revo?
That's concurrent with this 3-year sentence.
Okay. It either needs to be transferred up, in which I can do it, or Judge Winters does it, or I get some kind of, I just don't want to be signing off on his cases without permission.
I'm happy with whatever works for the court. We can either, if you have a process to do that today, we can. If not, I'll just go down to Ashley and see about getting it set on his next docket.
I don't have a process to do that.
Well, I'll handle the misdemeanor. We just do the other 3.
Okay.
If that's good with you.
Yeah, that'll work with me. What's the terms of the plea agreement on 34 and 35?
3 to do, 3 in the Department of Corrections, and there is a $1,500 fine on 30. Let me be sure I tell you the correct one. On 34, there's no fine on 35.
It's 3 years on both cases.
Correct, to run concurrent.
And what kind of credit time does he have?
You hit jail December 18th.
Yes.
He's been in jail since December 18th, 22, Judge.
But
It'll be on the judgment, Mr. Ross.
what does it say there on that judgment credit time? Just so I can pronounce it. It'd be on the first page of that judgment.
102 days.
102 days credit.
Correct.
And any restitution
No restitution.
and court costs. I'm presuming are $290 in each case.
290 on 34 and on 35, 290.
And any reimbursements?
Reimbursement on 35 is $20. Reimbursement on 34 is $20.
And then we're gonna have a 1245 and CR 2336.
Correct.
And then state, if you want to put something on the record later at the appropriate time regarding the misdemeanor, I'd have no problem with that. All right, Mr. Whitaker, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, Your Honor.
All right, thank you, sir. You can lower your hand. All right, your name is Jeremy David Whitaker. Is that correct?
Yes, Your Honor.
And Mr. Whitaker, are you a United States citizen who reads, writes, and speaks English?
Yes, I am.
Have you ever been diagnosed with a mental condition?
No.
In this case, you're represented by your attorney, Mr. Ron Wells. Are you happy with him as your attorney?
Yes.
Do you feel like you've had enough time to talk to him about all of your cases and that you've had all of your legal questions answered?
Yes.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
No.
And wherever your signature appears in those documents, you're telling the court that that's your true and correct signature?
Yes.
Mr. Wells, do you believe Mr. Whitaker to be competent today?
I do, Judge, based on our conversations.
And you've explained to him his rights as they pertain to each case in this plea agreement?
I have, as far as his trial rights, right to cross-examine, and he's ready to proceed today.
And you believe that he understands all those and he's intentionally, knowingly, voluntarily waiving those rights today?
I believe that's correct, Judge.
All right, Mr. Whitaker, you are charged by indictment with third-degree felony offenses of assault of an emergency medical services personnel or provider in each case, CR 2334 and CR 2335. Third-degree felonies carry a range of punishment of not less than 2 years in prison or more than 10 years in prison, and a fine, if imposed, not more than $10,000. You've heard the plea agreement that Mr. Wells read to the court. Is that correct?
Yes, Your Honor.
Is that your understanding of the plea agreement and what you want the court to assess today?
Yes.
All right, Mr. Whitaker, at this time, I'd ask you, how do you plead to assault of an emergency medical services personnel or provider, third-degree felony in each cause?
Guilty.
Are you pleading guilty to both of those cases because you are guilty of committing those crimes?
Yes, Your Honor.
And Mr. Whitaker, has anyone threatened or forced you to plead guilty here today?
No.
The court will accept the defendant's plea of guilt in each cause. Mr. Wells, any objection to states one, the stipulation of evidence supporting the pleas?
No objection.
All right, states one is admitted in each cause respectively, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor, a couple of matters. With regard to the misdemeanor, it is the state's agreement to give Mr. Whitaker essentially time served on that revocation. I've spoken with the prosecutors assigned to the county court at law. They do believe that that could be added to the Monday docket to get Mr. Whitaker resolved on that issue as soon as possible. If that will work for Mr. Wells, if he'll just contact Miss Anthony and let her know that our prosecutors are prepared to carry out that agreement on Monday. With regards to victim notification, Judge Miss Curry and I both were working on this case. I don't know what her contact has been with the two EMS workers. I can tell the court that I have spoken with the victim in the 36 cause number, the public servant being the detention officer at the jail. I've spoken with him about this case. I've spoken with him about his interactions with Mr. Whitaker. He is supportive of this plea. I know Ms. Curry has also spoken with jail staff about Mr. Whitaker, his mental state, and some other things that went into the plea agreement today. So I believe we are in compliance with everyone, but I don't know. I can't tell the court specifically that the EMTs have been advised of this particular deal. But the one victim that I have notified of the particular deal is in agreement with it.
Thank you, Ms. Heisel. Anything further from the defense, Mr. Wells?
No, Judge.
All right, Ms. Heisel, can you give me a brief summary of the evidence supporting the plea?
Yes, Your Honor. Mr. Whitaker was picked up by EMS for a medical emergency as they were transporting him, I believe, to Athens. Mr. Whitaker became violent in the back of the ambulance. He first assaulted the male EMT, then the female EMT who was driving the ambulance pulled over to the side of the road to assist. He then began assaulting her. Essentially, he eventually got out of the ambulance, hid underneath it until the sheriff's office was able to respond and take him into custody. When they got to the jail, he was placed in the restraint chair with what's commonly known as the spit hood placed upon him because he was acting very erratically. He calmed down a bit. They had a detention officer that was bringing him some water after his episode, at which time he took a drink of the water and then spit the water back into the detention officer's face.
Thank you, Ms. Heisel. Mr. Wells, any objection to that summary?
No, Judge, there's no objection.
Okay. All right, then, based on the evidence before the court finds that there is sufficient evidence to convict Mr. Whitaker of these offenses. Court will follow the plea agreement, and based on the recommendation of the state, court hereby convicts Jeremy David Whitaker of assault of an emergency medical service personnel or provider in CR 23-34 and CR 23-35. Court assesses punishment in each cause at 3 years confinement in the Texas Department of Criminal Justice Institutional Division. Court awards Mr. Whitaker 102 days credit towards those sentences for the time that he has spent in jail on that cause. Court orders $290 court costs in each matter, $20 reimbursements in each matter, and the court assesses a $1,500 fine in CR 23-34. The court takes into consideration under section 1245, cause number CR 23-36. Mr. Whitaker, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over with Deputy Everett to be fingerprinted. Is that all you have, Mr. Wells?
That's it, Judge. Thank you.
Thank you, sir. Appreciate you.
Judge. Like this, we don't mind if we don't, then I will see. Some point, some point on this. What does it do that? What he didn't think, where's that judge? So he's still gonna have, you're just gonna get 60 days on the misdemeanor verification to let the terms of this, but we still have to do the formality of the judge taking the plea. So I'll go with it right now. Okay, then, you know, they'll leave it right there. I'll, people will be brought over, why I need to come back here Monday.
So you leave the jail and they have to do just like you. So he'll be, taken on to the clients.
Yeah, and so back over here, that, well, I will work with Ashley, so maybe the afternoon instead of the morning.
Sometimes they do, we have some.
So I'll just go ask him where they come out. Thank you. Appreciate it. Okay, so you got any questions then? Okay, so we'll get this taken care of on Monday. I'll go ahead and keep these papers. And you got no more questions? Okay, I'm glad we're done. Thanks, Brian.
It's just.
Oh, boy. That's the first time I've seen it.
All interest rate, we'll get one for every case.
All right.
Right, are you Mr. Wellborn?
Yes, sir.
All right, Mr. Wellborn, let me see if your attorney, Mr. Schmidt, is Mr. Manning in that courtroom? And is he tied up?
Yeah, he's sitting right here doing nothing. Did you want to do?
Mr. Manning, I'm sorry, can I interrupt you for a moment to assist with Mr. Cody Wellborn from Henderson County? I'm sorry to interrupt. Mr. Manning, have you had an opportunity to review the indictments with Mr. Cody Lee Wellborn in CR 23, 32, and 33?
Judge, I do not have my file with me right away. I believe we discussed that he'd been indicted, but I don't know if we've been able to go over the indictments in person.
Okay, give me a second and let me pull those up.
Judge, I don't believe we have.
Okay.
Ready to go?
Just attempt to share the screen here. Are you able to see that, Mr. Manning?
Yes, Judge.
All right, Mr. Wellborn, can you see that on your screen as well?
Yes, sir.
Okay, and do you read and write English?
Yes, sir.
Okay, I'm gonna give you a moment to read that and then just let me know when you're ready for me to move the screen down.
Yes, sir. I have a copy of it myself. I've read it, sir.
Okay, great, thank you. I'll let Mr. Manning go ahead then.
Mr. Wellborn, is your name spelled correctly?
Yes, sir.
And you understand that at this point in time, they've charged a third-degree felony, but they've also added 2 enhancements, which raises your range of punishment from 25 years to life on this charge. You understand that?
Yes, sir.
Judge, I have advised my client's range of punishment. His name is spelled correctly. He understands the charge against him. At this time, we request to be set for pretrial, and his plea is not guilty.
Let me show you. I'm not sure if they're the same indictments or not, but let me see. That was 33. Here's 32. Mr. Wellborn, do you also have a copy of the indictment in this cause, CR 2332?
Yes, sir.
Okay. Go ahead, Mr. Manning.
Judge, it still looks like it's showing 33 still.
How about now?
Yes, Judge. And Mr. Wellborn, your name is also spelled correctly in this, correct?
Yes, sir.
We discussed this charge as well. You understand they've charged you with a first-degree felony and enhanced that as well. Same range of punishment as the previous. Is that correct?
Yes, sir.
Judge, his name is spelled correctly. He understands the charge. We've discussed that charge. He pleads not guilty and requests to be set for pretrial on that as well.
All right, the court will find that Mr. Wellborn has waived the formal requirements of arraignment. Court finds his name is spelled correctly in each indictment. Court will enter his plea of not guilty into the record for each cause. Court sets Mr. Wellborn for pretrial hearing. Mr. Manning, do you want this set April 25th, or would you prefer a little bit more time on May 9th?
Judge, we have a little bit further out. There's some significant discovery to go over on Mr. Wellborn's case, as well as there may be some factual things that he and I need to discuss with the DA's office.
All right, court sets Mr. Welborn for pretrial hearing on Tuesday, May 9th. That'll be at 1:30. Mr. Welborn, if you're on bail, it'll be at 9 a.m. If you're still in custody in Henderson County, then we'll make arrangements to possibly have you zoomed. If you're in our county jail, then it'll be at 1:30. Okay.
Yes, sir.
All right. If there's nothing further, thank you, Mr. Welborn. You're excused.
Absolutely. Thank you.
Judge, while I'm up here, I also have resets for Miss Michaela Williams. My understanding is that she's at a
Well-care, maybe well-care visit.
yes, Judge. She's at a appointment. We request that her case be reset.
All right, court calls cause number CR 21-314, State versus Michaela Allison Williams. Court was advised yesterday by jail staff that Miss Williams is pregnant and that she had a well baby or child care appointment this afternoon, and the court will waive her appearance today. Court reset her motion to adjudicate for contested hearing on April 27th at 1:30.
Thank you, Judge. I also have a reset on Mr. Randy Young.
Randy Leonard Young, CR 22-349. And you can test the pre-trials.
Judge, I have not had an opportunity to go to the discovery with Mr. Young since he's been incarcerated. My plan was to go over that with him last week, but there was some new information that came up regarding his co-defendant that I've provided to the state. I believe they're trying to verify that, and it may end up affecting the direction of this case and its disposition.
Right. Any opposition to April 25th?
No, Your Honor.
Judge, is that a Tuesday?
Yes.
Okay.
All right. Court sets Mr. Young for pretrial hearing April 25th at 1:30. Anyone else, Mr. Manning?
Yes, Judge. If we can call up Mr. Hicks and Mr. Thomas.
Braylon DeMonte Hicks, CR 22-356 and 399. Mr. Hicks, a separate pretrial.
Yes, Judge. Mr. Hicks and myself have begun going through the voluminous discovery on his case. We've also received an offer from the state. I would request for additional pretrial. We only had one pretrial with the evidence from the murder. I've sat down, we've gone over some of the most pertinent stuff, but my clients asked me to follow up on some other stuff that I've not been able to find as directly. And so we request additional pretrial on both cases.
Any objections from the state?
No objection, Your Honor.
All right, court will reset Mr. Hicks then for an additional pretrial on May 9th. Is that enough time, Mr. Manning?
Yes, Judge.
All right, we'll set Mr. Hicks May 9th at 1:30. Who's the other one, Mr. Manning? Mr. Thomas?
Judge, actually, if I could hold off on an announcement, Mr. Thomas, I have one more thing I was going to discuss with him. But we can call it Mr. Ehrenfeld instead.
CR 22-270, State versus Kevin Max Ehrenfeld.
Judge, Mr. Ehrenfeld was recently brought to our jail at the last setting. I requested a short set on this because I wanted to go over the discovery with him. When I met with him, we were missing officer reports, videos, and one of the videos was not working. I know the DA's office is diligently working on those and has been in communication with me about the status of those. But I have not had an opportunity to go over those with Mr. Ehrenfeld at his request before we move forward on this case.
How much time do you need, Mr. Manning?
Well, Judge, last check, and this information may be outdated. As I saw, there's a stack of DVDs at my desk when I got back. But at last check, they had a video that was not playing either on their system or being able to be copied, and I believe that was from Van PD. And so I don't know how long it's going to take to get from a new copy of that video from them.
Okay. Court will reset Mr. Ehrenfeld for a docket call on May 9th. State, do you have any more information for Mr. Manning on that?
Judge, I believe we're in the process of procuring all the videos. I know there was a question about the van video. I believe that we're in the process of resolving that. I don't know exactly where we are, but I will get with Mr. Manning, make sure we have everything we can possibly get him far in advance of the May 9th date.
I think Mr. Woodward.
As that was May 9th, is that correct?
May 9th, yes, sir.
And Judge, I believe that's all I have ready at this point.
All right, thank you, Mr. Manning. Mr. Schmidt, I don't see your client at the Henderson County Jail.
I don't see him either, George.
Let me see if I can ask Ms. Abraham to kindly contact Henderson County and see if we can't get Mr. Collier in front of the camera. Do you have anyone else that you're ready on while we're waiting, Mr. Collier?
Got announcements on Roseman and Shannon is the last name, and Dugan.
All right, Rosman Shannon, CR 2363. All right, go ahead, Mr. Schmidt.
Judge, was negotiating with the counsel for the state up until I guess a few minutes ago. Hopefully hoping for a resolution. At this point in time, it's become perfectly clear that we will have to have a contested hearing. I was hoping to avoid that, but if we could set this on the next contested docket for a contested hearing on the motion to adjudicate, I'd appreciate it.
State. Any objections with state?
No, Your Honor, we agree with Mr. Schmidt's assessment.
All right, court sets Mr. Shannon for contested hearing on April 27th at 1:30.
Yeah, you can.
All right. Mr. Collier, can you see and hear me okay?
Yes, sir.
All right, this is cause number CR 22-126, CR 22-127, State versus Keith Collier. Evidentiary hearing. Go ahead, Mr. Schmidt.
Judge, we do have a motion to suppress on file for Mr. Collier's cases. This has a companion co-defendant, Ms. Dobie, that was on the docket on Tuesday. The state has provided myself and the other attorney with quite a lot more evidence. I believe I received that from Ms. Heisel Friday or Monday, I forget. Either way, it's significant. We're going to ask that this, my motion as well as the hearing be passed. I think, and I think the announcement was, I reviewed it. There is probably, I guess I heard 500 different body cam videos on the thumb drive. I may be exaggerating, but there's a lot. So we need a little bit more time to go through that. And I've discussed that with Mr. Collier in detail the other day, so he's aware of it. So I guess we got a May date.
You want the May evidentiary day? That would be May 25th.
Yeah, May 25th should be sufficient for us, Judge.
Any position by the state?
Judge, we would be in agreement. I believe, to the best of my recollection, it was nearly 70 body cam videos and, or maybe it was, I'm sorry, maybe it was 47 body cam videos and over 700 photos, but it's a lot either way. So we would be in agreement with that.
Okay. All right. Court will reset today's evidentiary hearing for May 25th at 1:30. All right. All right. Thank you, Mr. Collier. You're excused.
Dugan Toms.
Dugan Lee Tom, CR 22-158.
Judge, I would make a similar announcement on Mr. Toms. I received an offer from the state and I was just able to relay that to Mr. Toms. I am convinced that the state does not intend to continue negotiations on their offer and will not change it. I relayed that to Mr. Toms, and he understands that. So under the circumstances, we asked that it be set for a contested on that April date.
All right, court will set Mr. Toms for a final hearing on the state's motion on April 27th at 1:30.
Okay.
Anyone else, Mr. Schmidt?
Yes, sir. I've got Zachary and Fulbright.
Zachorian Jure Fulbright, CR 22-214. The separate bail reduction.
Judge, I have a motion to reinstate bond in the indicted felony case, and I've got a writ on the rest. From a procedural perspective, neither myself nor Mr. Fulbright were aware that there are some misdemeanor causes filed in the county court of law. I wasn't aware that they were filed. I think Ms. Heisel alluded to that in her email to me where I misread it, but I did get the discovery for those sometime this afternoon. So just from that perspective, I can tell you that when I filed the writ, that was my understanding. It is not the case on a misdemeanor resisting and a misdemeanor possession of marijuana case. Those are filed. Obviously, I haven't reviewed them, and they're included on my writ. The motion to reinstate bond would still apply to those. However, I intend, and I'm not sure what the court's position is at this point, but I intended or intend now for sure to file a motion to transfer those misdemeanor causes to the 294th so that they can run with the indicted case as well as the other cases pending. But that has not taken place. So I want to make the court aware of that before we proceed on the writ and get the court's position on whether we're willing to proceed on the writ in totality or piecemeal it.
State, do you have a position?
Judge, I'm happy to take up in whatever order the court deems. There are 2 charges that Mr. Fulbright has never previously been booked in on. I believe everything else he has previously been booked in on and made bond. So obviously the situation between those 2 classes of cases are going to be a little bit different of an argument for us moving forward. But we obviously have no objection to Mr. Schmidt transferring everything up to run together. So it's really up to the court on whether you want to address it all today, or reset to transfer and then address it all. I'm prepared. Obviously, I've got Detective Morrison here to testify about the 2 new cases, but we defer to court on whatever you think the best scheduling is.
And Judge, we concede that the 2 newest felony cases, he has not ever bonded out on those. And the state did provide me with the arrest warrant affidavits this afternoon. So I'm aware of that procedurally. Those would be just a plain writ reduction request. But all the rest really would fall under the fact pattern contained in the motion to reinstate.
Let me repeat back things I've heard and things I believe to be the case. You tell me if I'm wrong. So Mr. Fulbright has 6 charges, 2 indecency with a child by sexual contact, 2 failed ID fugitives, 1 possession of marijuana less than 2, 1 resisting arrest. And what you've informed me of today is that the possession of marijuana and the resisting arrest have been filed in the county court of law. But the other 4 he is still not made bail on and has not been indicted, or they've not otherwise been filed. Is that correct?
No, Judge, I think we're close. It's my understanding that a possession of marijuana, bail set at 10,000, and a resisting arrest or search, bail set at 50,000. Those have been filed by the state as informations in the county court of law. We have a failed to ID, fugitive intent, failed to ID, burglary of a building. That's the instant indicted case. All of those cases, including the filed misdemeanors, it's my understanding that Mr. Fulbright was on bond for. The 2 that he has not ever bonded out of, and which were added the latest, were the indecency charges. Did that clear it up, or did I make it worse?
I think so. So you're asking the court to reduce bail on the 2 new charges and reinstate on the 2 failed IDs.
Well, what I'd like the court to do is reinstate on 2 failed IDs, a burglary of a building, possession of marijuana, and resisting arrest, and do a reduction on the 2 assaultive cases or indecent.
Yeah, I don't have anything on burglary of a building. I'll show that on his booking sheet, from the sheriff's office. But actually, I'm reading from your order on the writs. I don't have anything.
That would be included on the motion to reduce. So we have a filed case in your court, and that is the burglary of the building. So I use the vehicle of the motion to reinstate bail for that one, because obviously the writ would be, I don't think appropriate. But the other cases, I filed writs on all the rest of them. At the time, like I say, I was not aware that 2 misdemeanors had been filed. Otherwise, I would have done a motion to reinstate bails on those 2 cases, but they were included in my writ. So as far as the fact pattern that we would put before the court, as far as reinstatement is concerned, they would apply to all cases except for the 2 newest counts of indecency. And I brought it up initially because I didn't know they were filed, and I didn't know if the 294th court would hear our arguments on the filed misdemeanors, which are in the county court law.
The state doesn't have any objection, then the court will hear it and any ruling I would make, I would wait till I had jurisdiction of, that makes sense.
It does make sense. Thank you.
So if the state has no objection to going forward today, I can allow the defense to put on their testimony, allow the state to put on any testimony that so chooses, take it under advisement until such time that all cases are before the 294th, and then I can render a ruling on it at that time.
State would be in agreement to that, Your Honor.
Okay. Mr. Schmidt, are you calling your client today as witness?
Yes, sir.
All right, Mr. Fulbright, I'm going to allow you to testify for this hearing for the limited purposes of your motion to reinstate your bond or to set bail. Okay, so I'm going to ask you to raise your right hand, place you under oath. Sir, do you swear that the testimony you give the court today will be the truth, the whole truth, and nothing but the truth? So help you God. Okay, you've got to speak up. You can lower your hand. You've got to speak up. If I can't hear you, then I can't give you what your attorney's asking for. Okay.
Yes, sir.
All right, go ahead, Mr. Smith.
Thank you. Mr. Fulbright, at this point in time, you heard my recitation of your bonding situations and charges against you to the court, correct? Yes, sir. Was my recitation accurate in your estimation, or did I get something wrong? Accurate. It was accurate. Okay. So you were initially arrested on failed ID, burglary of the building, possession of marijuana, resisting arrest, correct? Yes, sir. You posted bonds on those cases, correct? Yes, sir. Okay. And at some point in time, the burglary of the building was indicted by the DA's office and sent for an arraignment. Are you aware of that? Did you receive notice of the court setting for your arraignment? You got to say yes or no. There's somebody over there writing it down. Yes, sir. Okay. At some point in time, after receiving notice, you were in an accident. Is that correct? Yes, sir. Do you remember the date of that accident? No, sir. Was it sometime in September of 2021? Yes. I want to make sure we got that right. It was September 2022. Is that correct? Yes, sir. Okay. And so were you hospitalized for that wreck? Yes. How long did you spend in the hospital? It was a week. Okay. And your court date was actually set to be heard on September 22nd, 2022. Is that right? Yes, sir. And at that point in time, were you in the hospital on that date? No, I was bedridden. So you'd been discharged. And did you have any serious injuries as a result of your accident? Yes, sir. And what briefly describe to the court what kind of injuries you sustained? I broke my neck and my ribs and my collarbone. And we filed a motion with the documents from Christus and as well as photographs of some of your injuries that the court would have forward as Exhibit A. Are those photographs of you? Yes, sir. And are they accurately depicting what they're trying to? In other words, the injuries you sustained in the wreck? Yes, sir. Okay. Judge, I'd move to admit those. They are on file with the court as an attachment to my exhibit, the photos, as well as the admission for the Christus Hospital.
No objection.
All right, there being no objection from the state, the court will admit. Are they just marked as Exhibit A?
They are, Judge, on my motion.
All right, court admits Exhibit A, which for the record includes documentation from Christus Health and also pictures.
For 9 photographs.
It's like appear to be 9 photographs and then a automated certificate of e-service. Those are admitted in evidence.
Thank you, Judge. Now, at the time when your hearing for arraignment was set, were you able to get out of the bed? No, sir. Were you able to drive? No, sir. Were you able to move around at all? No, sir. And did you contact the court to let them know that you were bedridden in your house? Yes, sir. And who did you speak to with the court? Do you remember? No, sir, I do not. Okay. But you called and talked to a clerk, presumably? Yes, sir. All right. So someone in your testimony is that someone in the district court knew that you were not going to be there based on your phone call to them. Is that correct? Yes, sir. Bail bond also contacted the court. And who's your bail bonds? Sydney. Cindy? Yes, sir. Hey, Cindy, bail bonds? Okay. When you were in bedridden, where were you living? Frisco, Texas. Who did you live with? My mother. Okay, and Frisco, roughly 2-hour drive from here? Yes, sir. Is that correct? Not including traffic. Okay. If you bond out again on these cases, is that where you'll return to live? Yes, sir. With your mother? Okay. So is it your testimony to the court that you did not intentionally fail to appear on your arraignment setting on 9/22, but that you were unable to based on your medical problems? Correct. And you'd ask the court to reinstate the bonds on those charges? Is that what you're asking? Please. Yes, sir. And have you had any conversations with your bondsman, Cindy, about whether or not she's willing to go back on those bonds? She said that she was. Okay. Now then, on the two newest charges, you have never posted bond on those cases as of yet, correct? Correct. And those bonds are set at $25,000 a piece. You understand that? Yes, sir. And you were arrested on these February 17th, 2023. Is that right? I turned myself in. You surrendered yourself to the Van Zandt County Jail? To Judge Dunn and Wills Point. Judge Dunn and Wills Point. Okay. And at the time when you surrendered yourself on those two warrants, were you aware that you had a warrant for not coming to court on? No, I wasn't. Okay. Now, obviously, you have not been indicted on those cases, but they're relatively new. I was provided a copy of the arrest warrant affidavits by the DA's office this afternoon, but we have not had an opportunity to go over those together, correct? Yes, sir. But you understand the nature of those charges? Yes, yes. Yes. And at this point, obviously, you deny those allegations. Okay. Now, overall, your bonds, according to your bookend, are set at $310,000 cumulatively. If the judge reinstates those bonds we talked about that you'd already made, you would still be left with $50,000 worth of bonds in which you are not currently entitled to a PR bond. Will you be able to make that $50,000 if those were the only two you had to bond out on? Possibly. And who would you rely on to help you pay those bonds? My mom. And what's your mother's name? Georgette Brown. And she's the one who lives in Frisco, right? Yes, sir. Okay. However, you were asking the court through your writ to reduce those bonds so that you can make it so that your mother can come up with enough to get you out, right? Yes, sir. Pending the outcomes of these cases. Now, if you were to make bond and the judge did grant the relief you requested, would you be able to make it back and forth to court from Frisco? Yes. And you understand if you fail to appear, obviously your bond would be revoked and you'd be back in jail. You understand that? Yes, sir. You also understand that you have two cases filed, misdemeanor cases filed in the county court of law. We just figured out you didn't know that until today, right? We should have known that, but I made you aware of that. You understand that those will have to be transferred as active cases. That's right. So you would have 3 filed cases, including the indicted burglary of the building, in which we have settings already, where we have to be back May 9th, I believe, for pretrial on those. So you're aware you can't miss any court. Yes, and can you assure the court that under the circumstances you will make it to court on all your hearings? I will make it to court. And is it your testimony to the court that you would have made it on your original arraignment date, but for your accident and your bedridden health problems? Yes. I'll pass the witness.
State your witness.
Thank you, Your Honor. Mr. Fulbright, were you represented by counsel back in September of 2022?
No, I'm not.
Okay, so it was just your bondsman and the court that you contacted about your accident, is that correct?
Yes, ma'am.
And here on Exhibit A that your attorney has entered in, I show that you were in the hospital September 10th and through September 12th. Is that accurate based on your memory?
Yes, ma'am.
Okay. And you said that you contacted the court back in September of 22. Did you provide this documentation that's been made part of the record today back then?
Yes, ma'am. I sent it in my bail bond, sent it to the court, but y'all kept saying y'all never received anything. I don't know why.
Okay, so you were aware that the court had not received documentation, even though it was your belief that you had sent the documentation through?
No, y'all, that was after the court date that y'all were telling me that y'all didn't send any, that y'all didn't receive anything.
Okay, after the court date, you received contact back from, do you recall who? Okay. At any point, did the court staff give you another date to appear in court? Okay. Mr. Fulbright, when did you become aware that you had a warrant or multiple warrants outstanding for the charge of indecency with a child?
I don't recall.
Okay. Was it before the date you turned yourself in to Judge Dunn?
Yes.
Okay. You don't have to give me an exact date here, but was it a good amount of time before you turned yourself in to Judge Dunn?
Probably a week.
Okay. Okay. And you did eventually surrender yourself, is that correct?
Yes, ma'am.
Mr. Fulbright, at any point in time, did any member of the district clerk or your bondsman tell you that you did not have to appear in court on the 29th?
My bail bonds did. She said that Judge Martin honored my rec and the pictures that they sent, but I guess it was a miscommunication.
Okay, do you have any documentation of that?
Just phone calls.
Okay, so just your word for it, basically. Your Honor, I would pass the witness, but would briefly like to clarify something for the record.
Do you want to clarify it this time?
Yes, Your Honor. Just before we proceed, Mr. Schmidt, there are actually 4 misdemeanors filed downstairs. I will send you an email with the cause numbers on there, just so when you do your motion to transfer, we make sure and get everything. We've set all the right charges, but there are 4 total filed cases downstairs. Just wanted everybody to be on the same page.
I'd object to the DA's office filing misdemeanors. Spare me. All right, thank you.
So those are 2 failed IDs, possession less than 2, and a resisting. Is that correct?
Your Honor, actually, there's 2 possession of marijuanas, 1 resisting arrest, 1 failed ID, all filed downstairs.
And I noted, sorry.
But that's okay. I'm just, seems like the more we talk, the more charges pop up. So just trying to wrap around it here.
There
So
is.
This is what I'm showing from the, this is what I'm showing. He's booked in on right here. But you are telling me this is not right.
No, it's right. She's telling you that there are more charges actually filed by information downstairs than I was aware of. I said there were 2. And that's what it shows.
But I'm showing that there are 1, 2, 3, 4, 5, 6, 7 total charges that he's being held on. 2 indecencies by sex contact, 2 failed ID, fugitive, 1 burr cab, 1 POM less than 2, 1 resisting arrest, search or transport.
That's what I had. That's what I understood he was being held on. But I don't know.
Judge, that is what the jail shows him to be booked in for. There is one of those failed IDs is filed, one of those failed IDs is unfiled. The possession of marijuana that shows on that sheet is filed. There is also another possession of marijuana that is filed downstairs. So I'm unsure. I don't know if the principal did not go off the bond on all the filed charges. I'm unsure about that. But there are 4 total charges filed downstairs.
And is one of those charges the resisting search or transport, or is it not filed?
Yes, Your Honor. Just for the record, I'm going to give everybody the cause numbers. 2022-253 is a resisting arrest. 2022-254 is failed ID. 2022-255 is a possession of marijuana. And then there's also a 2021-417 that's a possession of marijuana that looks like it was maybe a little bit older. But it is still open and pending downstairs.
Let me share my screen for just a moment. So Ms. Taberham brought to my attention. I'm not sure if I overlooked this. This is in regards to Mr. Fulbright's testimony regarding the motor vehicle accident and his failing to appear on September 22nd. But let me share my screen and I'll show you what Ms. Davis, or actually Ms. Brown, Chrissy Brown, shared with the court. So there's, and I don't want to share all his medical history on here, but we did receive that. Appears on 9/21, about 5 o'clock. So that would have been 5 o'clock, around 5 o'clock the day before. So I may not have been aware of that morning. So anyway, so to Mr. Fulbright's testimony regarding having information provided to his bondsman and they provided to the court, that appears to be correct.
Thank you, Judge.
Okay, any more questions, Ms. Heisel, or I think you said that you passed the witness and you wanted to clarify that we wanted to fill clarification and charge count clarification. Mr. Schmidt, anything further? All right, anything further from state?
Yes, Your Honor. State would offer at this time State's Exhibit 1, which is the arrest warrant affidavit and the arrest warrant in each of the 2 indecency charges that was provided to the court this morning.
Any objections, Mr. Burch?
Obviously, Judge, we objected here to say we understand the law.
All right, then the court will overrule the objection and the court will admit State's Exhibit 1 for the limited purposes of this hearing.
Judge, we would ask you to take judicial notice of State's Exhibit 1 at this time.
Court will take judicial notice of State's Exhibit.
Thank you, Your Honor. And then State would call Detective John Morrison.
All right, Mr. Investigator Morrison, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court will be truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Thank you, sir. Lower your hand to speak up loudly and clearly for me. Go ahead and decide.
Thank you, Your Honor. Investigator Morrison, would you state your name and job title, please?
John Morrison, I'm an investigator for the district attorney's office.
And what specific role are you assigned to here at the DA's office?
fugitive apprehension.
Hey, and did you become aware at some point of an outstanding warrant for Zachorian Fulbright?
Yes, multiple warrants.
Okay, do you recall when you became aware that he wasn't a wanted individual?
I believe it was around October of 22.
And did you at that time proceed to try to locate Mr. Fulbright and bring him in on the outstanding warrants?
Yes, myself and another investigator with the Van Zandt County Sheriff's Office went to several locations to try to locate Mr. Fulbright. We were unsuccessful at that time. I believe the other investigator had attempted to make contact with Mr. Fulbright and made him aware of the warrants at that time.
Okay, so back in October, y'all were unsuccessful, but there, to your understanding, was law enforcement that made Mr. Fulbright aware in October that he had outstanding warrants.
Yes.
Okay. And what measures were taken after October to locate Mr. Fulbright?
We contacted several family members. We went to a place that he showed, a place of employment in Terrell. Still unable to locate him. I then contacted multiple agencies, including the Office of the Inspector General, U.S. Marshals, all of our local agencies here in the county, as well as Denton County. I had information that he may be living in Denton County, Aubrey PD, just multiple agencies trying to locate and apprehend Mr. Fulbright.
And approximately how many man hours, I know it can be approximate, were spent trying to locate Mr. Fulbright?
Just by me or total, everybody involved?
Everyone involved.
Everyone involved. After
Calls for speculation. I don't think the detective would know the answer to that question.
Sustained.
Investigator Morrison, how many man hours did you personally spend on this?
personally, it was approximately 100.
And were you ever able to successfully make contact with Mr. Fulbright?
Personally, no.
Okay. When were you made aware that Mr. Fulbright was in custody?
I was contacted by Precinct 3 Constable Jeff Corn, who advised me that Mr. Fulbright was there at his office to turn himself in.
Okay. Did you go and confirm those warrants and transport him, or did you have Constable Corn do that?
No, Constable Corn done that.
Okay. Is it fair to say that you have extensive history on specifically these indecency warrants with Mr. Fulbright?
Say that again.
Would it be fair to say that you have a lengthy history with Mr. Fulbright with respect to these warrants?
Yes.
In your professional opinion, do you believe that Mr. Fulbright, if he was granted a lower bond or was able to make bond, would be a flight risk?
Yes.
Okay. And that despite him turning himself in, you still believe that he is a flight risk?
Yes, because I know that he was a passenger in a vehicle that was pulled over approximately a month before he turned himself in, which allegedly he had a medical episode and EMS was called, and he was transported by EMS at that time. So he wasn't picked up then, but was made aware of the warrants at that time.
Your Honor, I would pass the witness.
Mr. Schmidt, questions?
Yes, sir. Detective Morris, starting at the end and going back, you testified that you're aware of a traffic stop in which Mr. I just drew a blank, in which the defendant was a passenger? Is that
Yes,
right?
sir. Yes, sir.
Were you on that traffic stop? In other words,
No,
were you-
sir. I was contacted by the agency that performed the traffic stop because they knew I was actively looking for him.
and do you remember what date that traffic stop was?
No, sir, but I can get it.
That's fine, but at the point in which the traffic stop occurred, the warrants were active, correct?
Yes, sir.
That includes the indecency warrants, the newest ones, those were active as well, is that right?
Yes, sir.
Okay, so at that point, was local law enforcement or the law enforcement agency involved in the traffic stop aware of those active warrants?
Once they were able to ID the defendant and ran him through the national database, they were aware of the warrants.
Okay, but yet they did not take him into custody on those warrants to clear him out, is that correct?
No, sir, he was transported by EMS.
And did an officer follow him to wherever he was transported? Were you notified that he was being transported by EMS?
Due to, I'm sorry?
I said in a timely fashion where you could actually do something about it, I guess.
No, sir, I wasn't notified in a timely fashion, no.
And do you know whether or not whoever made contact with Mr. Fulbright, you weren't there, so do you have evidence other than a phone call that they made him aware of active warrants? And that he understood he had them?
On the traffic stop?
Sure, yeah, we can start there.
No, but I can get body cam.
Okay, that'd be helpful, but we're not sure right at this point. I'm not questioning you. I am questioning you. I'm not doubting. I'm just trying to make sure that your testimony is based on actual knowledge and not what you heard from somebody else. So then you said that you had spent about 100 man hours of your own trying to apprehend Mr. Fulbright. You listed the name of agencies that you contacted and resources you used. You did not list a Cindy Bellbonds. Did you contact her to ask her where she thought Mr. Fulbright was?
I don't believe I did, no, sir.
Okay, and in addition to that, you have the ability to run accurate reports or things like that where you can get the next of kin of an individual, right?
Yes,
Did you run one of those reports on Mr. Fulbright?
yes,
And did it list the names and potential residences of his immediate family members?
yes.
And did you make contact with his mother? And
I personally did not,
okay,
but one of the other agencies did.
did they contact her via phone or did they go out to that residence in Frisco to look for Mr. Fulbright? Or do you know?
It's actually in Savannah, Texas, which is in Aubrey, in Denton County. It's not actually Frisco. I did go up there, but I did not make contact with anyone at the home. We had several different agencies in that area doing surveillance. So I was up there doing surveillance, but never actually made contact with anybody myself.
Okay, and do you have any recorded evidence of a phone call or an email or a letter certified that was sent to Mr. Fulbright where a law enforcement officer made contact with him and made him aware of the warrants that were discussed?
No, sir, I do not.
Ultimately, when you do fugitive recovery as part of your duties through the DA's office, do you normally undertake those efforts for an active, uncleared original warrant, like the indecency cases, or would you do that on an individual who say, didn't show up for court and lost their bonds?
Well, I go after anybody that has any kind of warrant, mainly absconders, either from probation or your NISI warrants out of court, stuff like that. But I do also try to locate people with at-large warrants.
Sure, yes, sir. And so under these circumstances, as it pertains to Mr. Fulbright, was your attention or your efforts triggered based on the filing of the two latest arrest warrant affidavits and warrants for arrest?
Yes, they were. Yes, they were, because I was contacted by the original investigator on those cases, and he asked for my assistance in trying to locate Mr. Fulbright.
Okay, so it was at that point in which you became heavily active in trying to track him down,
Yes,
but not prior to that. Is that right?
correct.
And I think that the warrants were executed or issued September 29th, 2022. Does that sound right? Or do you have a copy of them?
Yes, I have a copy of them. Yes, September 29th, 22.
Correct. And so that
Yes.
was roughly, not roughly, it was exactly 7 days after Mr. Fulbright failed to appear on his arraignment for the other case. Does that sound right?
According to what's been stated, yes.
Okay. So at the time, 7 days earlier, Mr. Fulbright was in contact with the court through his through phone calls and through his bondsman. And ultimately surrendered himself when he found out that he had warrants. But yet you testify that you believe him to be a flight risk. I guess my question is, do you believe he's a flight risk because he was difficult to find, or because you have actual knowledge that he evaded being taken into custody?
Well, he was made aware of warrants and came up with a medical episode where he got transported, which was at least a month prior to him turning himself in. So why didn't he turn himself in sooner?
Well, do we know what the nature of the medical episode was?
I do not. I don't have medical records on that, no.
Yes, sir. And ultimately, it was serious enough that he was transported with an officer on scene who could have cleared those warrants, but didn't. So, I mean, we could speculate all day long whether he was actually told or actually understood or actually knew, but he didn't leave the scene or flee the scene. He was transported from the scene to the hospital based on your understanding, right?
Correct.
Thank you. I'll pass the witness, Judge.
Heisel.
Just briefly, Your Honor. Investigator Morrison, in the 1 week that Mr. Fulbright testified he knew he had a warrant before he turned himself in, what was the level of your, I'm going to call it a task force for lack of a better term, your task force looking for him? What was the level of activity and level of contact in that 1 week period?
I'm not understanding your question.
So between you and the other officers that were looking for Mr. Fulbright, in the 1 week period that he admits he knew he had a warrant, between when he found out he had a warrant according to him and when he turned himself in, what was the level of activity over that week? Was it sporadic? Was it constant? Was it aggressive?
As far as us trying to locate him,
Yes.
it was constant. I mean, I was working day and night. There was one day where I woke up at 4 o'clock in the morning to drive up to Savannah to do the surveillance, and worked into the nighttime that night. So it was pretty constant that week. We've even had multiple agencies doing that same thing, spending a lot of hours that 1 week.
And in that week, what actual contact was being made with Mr. Fulbright, Mr. Fulbright's family, actual people that would have relayed information to him that he was being looked for?
And
We
Judge,
were knocking on doors.
I would object to the question as overly broad, and that Mr. Morrison testifies specific to his personal knowledge and the efforts he on, unless there's evidence of a task force that needs to be submitted. I get that he's aware of goings on, but I mean, specifics. So I would object to broadness that he testified to his personal knowledge.
Mr. Morrison, do you have specific knowledge of this information firsthand, personal knowledge? or-
Yes, I have firsthand knowledge myself. I went to his grandparents' house in Terrell. Several of his, I'm sorry, did you say something, Mr. Smith?
No, sir, I didn't.
Okay, I heard somebody. So I went to several addresses myself, knocking on doors, asking his friends and his family if they knew of his whereabouts.
So you spoke, sorry, Judge, go ahead.
I was just gonna say, go ahead, Ms. Hodges.
Thank you, Ron. So you personally spoke to multiple people, relayed to them the information that he had a warrant. You never made contact with him though, is that correct?
That's correct.
Your Honor, I pass the witness.
Mr. Schmidt, any more questions?
Yeah, this is going a lot longer than it needs to, Judge, I understand, but just one quicker question. When you were activated, trying to look for Mr. Fulbright to execute the warrant for indecency, were you in contact with the lead officer on that case? I guess it was a Sergeant Cortez. He's the affiant on.
At the beginning during October, when he first asked for my assistance, myself and Mr. Cortez were actively trying to locate Mr. Fulbright together. Yes.
Do you have
But
any?
after,
Okay, I'm sorry. Go ahead.
but after that first couple of days, myself and Mr. Cortez were no longer actively engaged in looking for him together.
Do you know, and you may not, but do you know whether or not Sergeant Cortez interviewed Mr. Fulbright in his investigation prior to getting an arrest warrant on these charges?
No, sir, I'm not aware.
Okay, thank you. I'll pass it.
Anything further? Ms. Hodges?
No, Your Honor.
All right, thank you, Investigator Morrison. You're free to go.
Thank you.
You're welcome. Any further witnesses or evidence, Ms. Heisel?
No, Your Honor, state would rest.
All right, anything further from the defense? Mr. Schmidt,
Rest of closed, Judge.
would you like argument, Mr. Schmidt?
Just briefly, ultimately, I would say that there are a couple of things that we presented. I think that the DA's office, Ms. Heisel, won't dispute, and I think the court won't dispute, is that Mr. Fulbright was in an accident. He was severely injured. He was hospitalized. He was bedridden. That missed his September 2022.
And I'm sorry, Mr. Schmidt, we're getting a lot of feedback from the jail. Are there other people talking in there?
No, sir.
We're picking up a whole nother conversation. There's no one else in the jail talking.
No, sir. Sounds like Tyler, Mr. Woodbine.
It's on mute. All right, I'm sorry to interrupt, but Ms. Grisham could not hear. So just go back about 10, 20 seconds if you can.
Okay, yeah, I'll start over. So ultimately, I think what I was trying to say is we got the medical record. Cindy Bell-Bonds did contact the court and present the court with that information. And so I don't believe right now that there's any dispute of Mr. Fulbright's claims that he was injured and unable to make it to court for that date. So we would argue that the bonds that he was on at the time that the NISI was issued, we would argue that he was physically incapable and attempted to and did through his bondsman contact the court and provide documentation to the same. The other issue though is that Detective Morris's testimony, I understand that, you know, when you have newly issued active warrants for what's listed as second-degree felonies, people are law enforcement motivated to get that person. However, there's no indication based on the testimony he provided that even though they made these efforts to track him down, that Mr. Fulbright had any idea that they were active warrants. Matter of fact, generally speaking, they don't even let them know because they don't want them running even further. So at the time he missed court, which was 7 days prior to Detective Morrison being activated on the task force, I guess, we know that his bondsman knew exactly where he was. And I don't think that he moved from that spot for some time. So I would say, Judge, that although I understand out of the blue trying to locate someone to execute an arrest warrant, I'm not going to claim that it's an easy job because I haven't done it. But just because they were unable to locate him does not mean that he is a flight risk. They couldn't find him, but there's no testimony that he was actively evading at that point in time, and ultimately he turned himself in. And I can't keep track of the timelines after the warrants were issued on the indecencies, but it seems to me Mr. Fulbright's testimony is that he turned himself into the JP court roughly a week or 10 days after he found out that the warrants were there. That's the opposite of a flight risk, Judge. We would say that under the circumstances, given the evidence presented based on the original NISI and even on the warrants, we'd ask the court to grant the motion to reinstate, apply that reinstatement to those cases that were actively bonded at that time that the NISI was issued. In addition, on the two cases that he has not bonded out on, those would be the indecency cases, those set at 25,000, we would ask the court reduce those. I would note for the court's attention that the affidavits filed and relied on by Detective Morrison, I've reviewed them and there's no indication whatsoever based on what I have now. Obviously, it's limited that the investigating officer ever made contact with Mr. Fulbright, ever asked him about these allegations. He simply did an interview in a CAC and got a warrant for his arrest. That's fairly typical. However, I would say that, we can argue whether or not it's appropriate or a thorough investigation based on what's before the court right now, and that is bond issues. We know that based on what I have, that they didn't contact Mr. Fulbright and even let him know that they were investigating. So there's no indication that he would have known that these warrants were active. So based on that, based on the fact that he did surrender himself, we'd ask the court to grant the relief as requested, to ask for a reduction on those $25,000 bonds to $10,000 each at this point, unindicted. And I think that's all I got.
So you said the defendant's asking for 10,000 on the two new indecencies, and then 75,000 reinstatement on the burglary of a building from the NISI. And then what about the misdemeanors that may be transferred up?
Judge, I would say that on those, for the sake of simplicity, the misdemeanor cases, we would ask that he be granted a PR bond on those, because I know that ultimately the paperwork becomes untenable on reinstatements. So a PR bond on the misdemeanors, a reinstatement on the burglary of a building, and a reduction on the indecency cases to 10 each, which would put him at roughly, he would have to post an additional $20,000 surety at this point in time, if my math's correct, to be able to bond out.
All right, thank you, Mr. Shen. Ms. Heisel, before you argue, on the filed misdemeanor cases, was Mr. Fulbright entitled to a PR prior to the filing of any of the misdemeanor cases?
Judge, I don't know. And because I don't know, I told Mr. Schmidt I would agree to PRs on all of the filed misdemeanor cases, just because I haven't dug into it deep enough to know whether they were filed within 15 or 30 days respectively. So state's not contesting that. I'd be happy to sign off on that, or have the court sign off on it.
All right, go ahead, Ms. Heisel.
Thank you, Your Honor. Obviously, I think the contact between Mr. Fulbright, Ms. Davis, and the court that you, Judge, showed us on your screen today was first I've seen it. I'm assuming it's the first that Mr. Schmidt has seen. And based on that, I think the state would be in agreement with Mr. Schmidt's motion with respect to particularly the filed Berghab, but then any subsequent bond revocations that were based on the failure to appear, given the fact we now know for certain that Mr. Fulbright did contact the court, did provide documentation to the court prior to his court date. I think that that's fair, Your Honor, which leaves us mainly with the two new cases, the two new indecency cases. We would ask the court not to reduce the bonds on those. First of all, Mr. Fulbright testified that if that was the only bond he had left to post, that he believes he may be able to make $50,000 bond. Your Honor, further, he has been in jail. I don't have an exact date, but just a little over a month, nowhere close to the 90 days for us to indict this case. I will tell the court that as of today, we do not have a case submitted to our office for either one of those charges. But we are hopeful that we would be able to get those filed in before 90 days. Further, Your Honor, Mr. Schmidt and I are just going to have to agree to disagree about what Mr. Fulbright knew, when he knew it. It is the state's contention that, and the state's argument that Mr. Fulbright, although he did turn himself in, only did that after receiving immense law enforcement pressure to a variety of sources around him for a sustained amount of time, that he did eventually turn himself in, essentially when there was nowhere else to go. And so for that reason, we do believe that he's a flight risk. We would ask that you hold his bonds where they are.
Anything further, Mr. Schmidt?
Judge, I could counter argue, but I think the court's heard enough. So we'd rest in club.
Okay. All right, then, based on the arguments of counsel, the evidence presented today, the court will reinstate the bail amount at $75,000 on the burglary of a building charge. Court finds that there's an agreement amongst the state and the defense for personal recognizance bonds on the misdemeanor charges. So court's not going to rule on that, as parties have agreed. The court will deny the defendant's request to reduce bail in the indecency with child by sexual contact cases, and the court ordered that bail will remain at this time at $25,000 in each case.
Thank you, Judge. And I think I submitted a proposed order with a lot of spaces for blanks.
I'll figure that out and I'll make it work.
Thank you, sir. I would ask that if you could have your coordinator send me a copy of that executed order when it's done. That way I can reference that with those that might want him out.
Yes, sir, will do.
Thank you, sir. I think that's all I have.
Let's see, and you said we already have a setting on this, is that correct?
Yes, sir. We're coming back for a pretrial on May 9th.
Okay. Yes, sir. I believe that is all that you have.
Thank you, Judge.
Mr. Manning, are you ready on anything?
Judge, I'm wrapping up the last piece of paperwork.
Yes, sir. Go ahead. Take your time. Let's see, is Mr. Michael Cubby?
Yes, sir.
Mr. Cubby, if you'll come forward. All right, Mr. Cubby, this is cause number CR 2154, wherein you have a motion to revoke that has been filed regarding your third-degree felony offense, injury to a child, elderly, or disabled individual. Mr. Cubby, are you requesting a court-appointed attorney?
Yes, sir. I'm in the process of requesting one. They sent me a paperwork yesterday regarding that I had a couple of things missing off of the form, and I'm in the process right now.
Okay, so you're gonna refill out this form and everything that's got blanks right here, you're gonna fill all of that out for me. That's the only way that I can thoroughly review whether or not you're indigent under the law so that I can appoint you an attorney. You understand that, correct?
Yes, sir. I have a quick question. How do I fill that part out? I mean, they say no slashes, no zeros. But
Well,
that's what I'm having problems on.
Well, no, it says if it's incomplete or it's all zeros or NA will result in your application being denied. So if you don't have child support, you put 0, but there's gonna have to be income or assets. I mean, you're living, so you
Yes,
know,
sir.
you're not dead from not eating or drinking or moving about. And so you need to fill that out as thoroughly as you can. If you don't have any money in the bank, put no money in the bank. But if you have assets, if you have truck, vehicle, 4-wheeler, you need to list those things so that we can review it.
Yes, sir.
All right. So what I'm going to do is I'm going to reset you for next week for April 4th.
Yes, sir.
I'm just going to fill out that paperwork and let my coordinator have a chance to review that so we can determine if you're indigent. And you're telling me at this time that you're indigent and you don't have the ability to hire an attorney. Is that correct?
Yes, sir.
All right, we'll fill that out and they'll send it back over and my coordinator and I will look at it.
Yes, sir. Thank you, Your Honor.
You're welcome.
Okay.
Is Mr. Penny in the office, in the courtroom? Mr. Penny, come on up. All right, this is cause number CR 22390, State versus J. Warren Penny. Mr. Penny, are you aware that your attorney, Mr. Patton, filed a motion for continuance?
Yes, sir, I am.
And the court has granted that. I don't recall what date I have you reset to. Give me just a moment. I'll see if I can pull that up. Looks like I have not placed a date on that yet. Let's see. Let's do that now then.
The sooner the better, Your Honor.
Yeah, and today it looks like it was supposed to be an evidentiary hearing that your attorney requested. So my next evidentiary date, Mr. Penny, is April 27th. So we're going to set it for April 27th. So about 30 days. Okay.
Yes, sir. May I ask a question, Your Honor?
Yes, sir. But I want to caution you. I'll try to answer your question. I'll tell you that I can't give you legal advice, and I would admonish you not to say anything that could be used against you in court because we are in court and the prosecutors are present. So go ahead.
Oh, am I being held without bond right now in Van Zandt County?
I don't. If it's a motion to, let me see here, bring pre-trial. See, your bondsman went off your bond. Is that correct?
I'm not sure, Your Honor, but I haven't broken any of the conditions of my bond.
Yeah, it looks like your. Let me make sure I read this right. It looks like your bondsman went off your bond March 14th. Here, let me show you.
So does that mean that another bondsman could pick me up on the same bond?
Let me answer your questions one at a time, if you will, just a second.
Apologize.
It's okay. All right, so this is you. This is your surety here, C. Pickens. You arrested on another charge at all?
No, Your Honor, I wasn't. However, apparently warrants were issued out of another county, but I was not aware of them. And my attorney, in fact, even called that county to ask them if I had warrants, and they wouldn't disclose that information to him. So there was no way for me to know that I had the warrants. But I paid Easy Pickings bail bonds all their money. I called every week and checked in. I didn't break any crimes as far as I know. So I don't understand why I
And let
can't.
me ask you a question. So did I hear you say that you were picked up on other charges in another county?
No, sir, I wasn't picked up in another county on other charges. However, a warrant was issued without me knowing. So when I came through Canton, and I guess they ran my tag, I don't know what their reason was for stopping me. But when they ran my plates, I guess, this is speculation, they seen I had warrants out of the other county. So they arrested me for those warrants. But then they pulled my bond for no reason.
Okay,
Well-
so that's the clarification. So you were arrested on something other than this case.
Judge, I may be able to clarify. It appears from the jail records that Mr. Penny is being held on, it looks like 1, 2, 3, 4, 5, 6 felony warrants out of Wood County in our jail. So I believe that's probably why Miss Pickens went off based on the document you're seeing, is because he was going to be held likely on those 6 or 7 warrants out of Wood County. And that's probably why they went. I mean, that appears to be what it says right there, is because he's going to be incarcerated on other things as well.
Your Honor, that's true. But does that mean that I have no chance to bond out of here to go there and face those charges?
No, you do. Here's your new bail amount right here.
That's what I wanted to know. Thank you, Your Honor. Nobody ever told me that. They just acted like I had a no bond all this time. Thank you.
Yeah, you're very welcome. All right, we'll see you back on April 27th. Okay.
Thank you, Your Honor.
You're welcome. Thank you, Mr. Woodward. I appreciate your help.
Yes, Judge.
Mr. Randy, you ready?
Yes, Judge.
All right, who are you ready on?
Judge, we can start with Mrs. Taylor Moore.
More?
Yes, Judge.
All right, this is cause number CR 18-42, State versus Kayla Jo Moore, set for plea on motion to revoke. Is that correct?
Yes, Judge. And we had an agreement that was predicated on her paying a significant amount of money, or her people paying a significant amount of money. And unfortunately, I dropped the ball on that, Judge. And so I'm going to request that we reset her to Tuesday so I can get in touch with her family. And we can get a payment arranged to satisfy the plea agreement with the state.
All right, court will set Ms. Moore for plea on April 4th, next Tuesday at 1:30. Who's next, Mr. Meeting?
Judge, take your pick. We got a bunch of pleas. I got the top one I got is Mr. Jacory Thomas.
All right, Mr. Thomas, come on up. This is cause number CR 16-69, CR 19-123. Mr. Thomas, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yeah.
All right, thank you, sir. You can lower your hand. All right, give me a second, Mr. Haney. Let me pull up his motions.
And Judge, while you're looking at that, just to confirm with the state, I believe we are abandoning counts 2 and 3, which are the new offenses out of Dallas County.
Can you see both of those documents, Mr. Manning?
Judge, we can see the one for CR 1669. I have hard copies of both, and we've gone over those in court today.
All right, so Mr. Thomas, it appears that you were before the court on March 7th, 2017. You pled guilty to the offense of aggravated assault with a deadly weapon, a second-degree felony. The court heard the evidence, found that there was enough evidence to convict you, but the court followed your plea agreement that you and the state recommended. And the court deferred a finding of guilt, placed you on 8 years of community supervision, ordered you to pay a $1,500 fine. And during your period of probation, the state filed its motion to adjudicate and revoke and alleged 13 separate counts in that cause. And in cause number CR 19-123, you also appeared for the court on June 13th of 2019. Pled guilty to the second-degree felony offense of burglary of a habitation. The court heard the evidence, deferred a finding of guilt, placed you on probation for a period of 5 years, did not assess a fine, and then during your period of probation, the state had filed a motion alleging that you violated your probation conditions, and they alleged, again, 13 separate counts of ways of doing that. Have you had enough time to go over each one of these motions to adjudicate with your attorney, Mr. Manning? You have. And do you feel like you've had enough time that you've are satisfied that you've had all your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
Yes, sir.
Mr. Manning, do you believe your client to be competent today to enter into a plea agreement?
Judge, I believe he is competent. Mr. Thomas and I have had multiple opportunities to discuss. He has a history of mental health, and we've had multiple opportunities to discuss how that affects what's going for today. But I do believe he has been involved throughout the process, and he has been able to make a rational decision today based on the information that's been provided to him.
Okay. And Mr. Manning, can you tell me what the agreement is today?
Yes, Judge. In both causes, the agreement is that upon plea of true, the amended motions to adjudicate that the defendant's guilt be adjudicated and community supervision be revoked. Punishment is to be assessed at 4 years in each cause, which will be running concurrently, as well as a balance of financial obligations. In CR 1669, the financial obligations appear to be $1,500 for fines and court cost of $465.42. The total jail time credit that he has is 252 days credit. In CR 19-123, the fine is $2,000 and court costs of $350. Jail time credit of $199. A judge, I'd also point to the court. I think it's reflected in here, but I don't have the court cost sheet. But Mr. Thomas's family made a payment, a pretty significant payment towards his back fees yesterday or Tuesday, I believe. And so that was applied, and that was part of our deal going forward today.
Did you say his credit time was 199 days on CR 19-123?
That is correct, Judge.
Okay. And I heard you say it. I didn't hear a response from the state. Is the state abandoning any counts on either motion?
Yes, Your Honor. It's count 2 and count 3. I believe it's the same on both motions. Both of them are the Dallas County offense. What I was checking for The judgment is still going to be correct, however, because he still violated condition A of his probation, because there was a Van Zandt County charge that he is going to plead true to in this agreement today. So it wouldn't change the letters that he violated, but it would change the counts.
So state abeyance counts 2 and 3.
Yes, Your Honor.
And I've interlineated on the motions that are attached as evidence.
All right, Mr. Thomas, then I'm going to ask you, how do you plead to the counts contained in CR 1669 as to counts 1, 4, 5, 6, 7, 8, 9, 10, 11, 12, and 13? Are those counts? Actually, those are going to be the same counts in each motion. Also, the motion for CR 19, 1, 2, 3. How do you plead to those counts? True or not true?
True.
Are you telling me that all of those counts that the court read are true because, in fact, what they're alleging is in fact true?
Yes, sir.
You're not just saying that to get a plea agreement. Is that correct?
Yes, sir.
And has anyone threatened or forced you to plead true to any of these counts today?
Yes, sir.
All right, court will accept the defendant's plea of true at this time. Mr. Manning, any objection to the admission of the defendant's waiver of rights and plea of true evidence?
No objection, states 1.
States 1 is admitted in each case, and the court takes judicial notice of the defendant's judicial confession in each case respectively. Anything further from the state?
No, Your Honor.
Anything further from the defense?
Judge, I just point out we arrived at this agreement for Mr. Thomas due to Mr. Thomas has had a rough go of life, and that has been brought on both through some of his self-inflicted substance abuse, but also some mental health issues and some health issues as well. Judge, he has a strong support system that's advocating for him, and I think that once he gets out, he'll be able to be a productive member of society. He's taken responsibility for his actions, and my hope is that that continuation will help him be out there and be not involved in the justice system any longer.
You agree, Mr. Thomas?
Sure.
Okay. All right, then, based on the evidence before the court finds that Mr. Jacory Lamont Thomas has violated the terms and conditions of his community supervision. Court will follow the plea agreement, the recommendation of the state. Court hereby, were these MTAs or MTRs? Because I think it said that they were MTAs. Is that correct?
That's correct, Judge.
My docket says MTRs, so I wanted to make sure I had that right. Court hereby adjudicates the guilt of Mr. Thomas in each case respectively. Court revokes his community supervision, assesses punishment at 4 years confinement in the Texas Department of Criminal Justice Institutional Division. The court orders him to pay the balance of his financial obligations. Court awards him 252 days credit to CR 1669. And the court awards him 199 days credit towards the sentence in CR 19-123. And court finds that the state has abandoned counts 2 and 3, and the court will order these sentences to run concurrently. Mr. Thomas, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Please step over to Deputy Everett. He's going to take your fingerprint. Who's next?
Judge, I have Lauren Northcutt.
Ms. Northcutt, CR 21-232. Ms. Northcutt, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Thank you. What's the plea agreement, Mr. Manning?
Judge, we're going to adjudicate her and place her on straight probation. So upon plea of true state's motion to adjudicate defendant's guilt will be adjudicated, punishment assessed at 5 years, TDCJ, probated for 3 years, and a balance of financial obligations. The financial obligations currently pending are a fine of $2,444.65. Court costs the amount of $65.62, and reimbursement fees of $834.73. Additionally, Judge, as part of the agreement for this probation, I believe, let me double check that it's in here. She will have her back time of 42 days that's been previously served, that will be a condition of probation that'll be eaten up in this plea.
And is probation supportive of placing her back on community supervision?
Yes, sir.
All right, and so before we go any further with this, Ms. Northcutt, I want you to tell me why I should entertain this. Why should I put you right back on something you were already on?
I'll be living closer to Canton. I'll be able to make my probation hearings and my community service, as well as I have a better support system to be able to pay my fines.
You're not going to be stealing stuff anymore?
No, sir.
All right. The rope that you were given is becoming shorter and shorter. You understand that, right?
Yes, sir.
I usually don't like putting people back on the same conditions that they're already on when they violate. So better be thankful to Mr. Manning and the state and Ms. Burns and her department for allowing you another opportunity. All right, Ms. Northcutt, has anyone threatened you, forced you, pressured you to make you feel like you had to enter into this plea agreement today?
No, sir.
So this time I'm going to ask you, how do you plead to counts? And you have the Mr. Manning, do you have the motion there with you so she can read along?
Yes, Judge.
So Ms. Northcutt, how do you plead to counts 1, 2, 3, 4, 5, 6, as alleged in the state's motion to adjudicate? Are those counts true or not true?
True.
You're telling me that they're true because in fact, what's alleged is true. You're not just saying that so you can get another shot at probation, correct?
Yes, sir.
Court will accept the defendant's plea of true to each count alleged. And is there any objection to the admission of the defendant's waiver of rights to plea of true and evidence?
No objection, Judge.
State's evidence is admitted and the court takes judicial notice of Ms. Northcutt's judicial confession. Anything further from state?
No, Your Honor.
Anything further from the defense?
No, Your Honor.
All right, court finds that Ms. Lauren Frances Northcutt was before the court on October 26, 2021, pled guilty to the offense of assault of a family or household member, a third-degree felony. In the court heard the evidence, deferred a finding of guilt, placed her on community supervision for a period of 4 years. Court also assessed a $2,500 fine, and it was during her period of community supervision that the court finds that a motion to adjudicate was filed by the state, alleging violations in 6 counts based on the judicial confession today. The court finds that Ms. Northcutt has violated the terms and conditions of her community supervision. Court finds each count alleged to be true. Court will follow the plea agreement reached by the defendant in the state today. Court hereby adjudicates the guilt of Lauren Frances Northcutt by convicting her of assault of a family or household member with previous conviction, third-degree felony. The court assesses her punishment at 5 years confinement in the Texas Department of Criminal Justice Institutional Division. The court again will suspend that sentence and place her on community supervision for a period of 3 years. The court orders her to pay the balance of her financial obligations previously imposed. The court orders her to serve 42 days in jail as a condition of community supervision. The court will award her credit towards that condition of community supervision for time served. Ms. Northcutt, you're hereby remanded to the custody of the probation department so they carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted, and then Ms. Burns will give you information about your next step on probation.
Thank you, Your Honor.
You're welcome. Like next, Mr. Manning.
Just we can do Miss Stephanie Rios.
Stephanie Rios, CR 21309. All right, is this a plea today too, Mr. Manning?
It is, Judge. This is going to be a plea for time, 2 years TBCJ institutional division. There's a fine of $4,000, court costs of $290, reimbursement of $155, and Ms. Rios has 43 days jail time credit.
All right, Ms. Rios, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. You can lower your hand. Ms. Rios, are you a United States citizen who reads, writes, and speaks English?
Yes, Your Honor.
Have you ever been diagnosed with a mental condition?
Yes, Your Honor.
Can you tell me about that?
I have anxiety and depression.
Are you currently on medication or under treatment for that?
Yes, sir.
Do you feel like you have a rational understanding of what's going on in in court today? You're not being affected by your anxiety or depression?
No, Your Honor.
Okay. And you're represented by your attorney, Mr. Manning. Are you pleased with Mr. Manning and the work he's done for you?
Okay. Good, my lawyer.
Do you feel like you've had enough time to talk with him? You've had all your legal questions answered?
Yes, Your Honor.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
No, Your Honor.
Mr. Manning, do you believe Ms. Rios to be competent?
I do, Judge. There was some question about her jail time credit, and I've explained to Ms. Rios that the only credit that can be given to her in this case must come from when she was in custody here or she was in custody somewhere else with a hold from our county. It appeared to be some discrepancy as to when she was in custody and notified her bondsman that she was in custody in Denton County and when a actual warrant or bond forfeiture was filed. But I explained to her that if she feels like the dates that were given were inaccurate or that she has documentation otherwise, that she can protest that she gets down to TDCJ.
Is that true, Ms. Rios?
Yes, Your Honor.
All right. Ms. Rios, then you are charged by indictment with a third-degree felony offense of unlawful possession of a firearm by a felon. That carries a range of punishment of not less than 2 years in prison or more than 10 years in prison and a fine which cannot exceed $10,000. Understanding the plea agreement, understanding the range of punishment, how do you plead to that charge?
Yes, sir.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, Your Honor.
Has anyone threatened or forced you to plead guilty today?
No, Your Honor.
All right, court accepts the defendant's plea of guilt. Mr. Manning, any objection to state's evidence?
No objection to states one.
States one is admitted and the court takes judicial notice of Ms. Rios's judicial confession. Anything further from the state?
No, Your Honor, we would rest and close at this time.
Anything further from the defense?
Just briefly, Judge, may I call my client?
You may.
Ms. Rios, during the course of my representation with you, that's been both while you were on bond and while you were incarcerated. And we've discussed throughout the course of that representation, different potential defenses and whether or not they would be factually applicable to your case. Is that correct?
Yes.
Okay. And you understand that you have an absolute right to go to trial. You have an absolute right to contest the evidence, but that with some of those defenses that would require you to admit to the offense and then just try to justify the factual reason why you violated the law. Is that correct? Okay. And you understand that you're waiving those potential defenses as well as your right to go to take this to trial and argue those facts in order to take this deal today. Is that correct?
Yes.
Okay. And no one's forcing you to do that, but you're doing it after having discussion and consulting with me as well as the facts of your case. No further questions, Judge.
Any questions from the state?
State has no questions, Your Honor.
All right, then, Mr. Woodwhite, can you give me the facts to support the plea?
Yes, Your Honor. On the date in question, the Texas Department of Public Safety Highway Patrol pulls the defendant over for going 90 and a 75. The state trooper sees drug paraphernalia in the cup holder, which the defendant attempts to cover with her purse and has her step out of the vehicle. While getting out of the vehicle, the defendant throws the paraphernalia out the passenger window. DPS then does a probable cause search based on all of those facts and finds a .25 caliber Raven Arms handgun inside the vehicle and arrests the defendant. Miss Rios is convicted of state jail theft in 2015. This is more than 5 years after her release, but she is in a motor vehicle on the highway, not her residence.
Thank you, Mr. Woodwhite. Any objections, Mr. Manning?
If I have just one moment.
Yes.
Judge, while there are, as I said with the testimony from my client, while there are facts that my client would contest, the specificity for support on this particular charge is uncontested. We would have a difference as to her actions once she was pulled over. But as I said, as for the reason for the stop, the ability to search the vehicle, and the weapon that was found, we do not contest those.
All right, thank you, Mr. Manning. All right, then based on the evidence presented to the court finds that there is sufficient evidence to convict Ms. Rios of this offense. The court will follow the plea agreement between the state and the defendant, and on the state's recommendation, court hereby convicts Stephanie Rios of unlawful possession of firearm by a felon. Court assesses her punishment at 2 years confinement in the Texas Department of Criminal Justice, orders her to pay a $4,000 fine, $290 court cost, $155 in reimbursements. The court awards her 43 days credit towards her sentence for the time that she has spent in jail on this cause. Mrs. Rios, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Please step over to Deputy Everett. He's going to take your fingerprint. Who's next, Mr. Manning?
Judge, last but not least, Ms. Kristen Sipes.
All right,
And-
this cause number CR 22-394, State versus Kristen Sipes. Go ahead, Mr. Manning.
I apologize, Judge. Just to clarify the record, Ms. Sipes has a sister who has used her name in the past, as well as her date of birth, and other identifiers. They also are very close in appearance physically, and so this is a mandatory probation case, and the state has offered probation on it. But this will be Ms. Sipes, as far as my information goes. So Ms. Sipes' first interaction with the justice system, and I've explained to her that as she will be fingerprinted today and a number associated with her, that any future disputes as to her identity and involvement in the criminal justice system can be sorted out through this judgment and this TRN number associated with this case.
Who is her sister?
Jessica Sipes.
Okay. All right, Ms. Sipes, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Right. And what's the plea agreement, Mr. Manning? You said it's probation.
Yes, Judge. It's a possession case, less than 1 gram, PG1, at state jail offense. The plea agreement is that a finding of guilt will be deferred, punishment assessed at 3 years community supervision, and a fine of $2,500, restitution in the amount of $180. Fine will be $2,500. Court costs will be $290. Reimbursement will be $605, and restitution will be $180.
Any 1245s?
No, Judge. This believe. Let me double check my file. I believe this is the only case that I was appointed on, and the only case I'm aware of for Ms. Sipes. There was no other holds for her at my last check.
Okay. All right, Ms. Sipes, you are charged by indictment with a state jail felony offense of possession of controlled substance in felony group 1, less than 1 gram. That carries a range of punishment. If you were to be convicted of that offense and sentenced, you could be facing a potential punishment range of not less than 6 months in prison and not more than 2 years in prison, and a fine of not more than $10,000. You've heard the plea agreement with Mr. Manning here today. That is 3 deferred plus $2,500 fine, court costs, restitution, and reimbursement fees. Is that correct?
Yes, sir.
And are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
Mr. Manning is your attorney. Are you pleased with the work he's done for you?
Very much, sir.
You feel like you've had enough time to talk to him about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
All right, Mr. Manning, you do believe Ms. Sipes to be competent today to enter into this agreement?
Yes, Judge. I don't know if it was the nervousness or other factors, but we went over it multiple times and I was able to answer all questions that she posed for the paperwork.
Okay, and have you explained to her the advantages and disadvantages of a deferred adjudication?
I have, Judge.
And Ms. Sipes, you understand that if I go along with this agreement today and place you on deferred community supervision, if you violate any of the terms of your community supervision, the prosecutors for the state can file a motion to adjudicate you. That means a motion to convict you, bring you back before the court and subject you to a hearing. And if they prove to the court that you violated your community supervision, the court could do a number of things, including convict you of the offense, revoke your community supervision. The court could sentence you to prison anywhere between that minimum of 6 months all the way up to a maximum of 2 years. You do understand that, correct?
Yes, sir.
All right, and you still wish to go forward with your plea agreement today?
Yes, sir.
All right, Ms. Sipes, then how do you plead to possession of a controlled substance in Penalty Group 1 less than 1 gram?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened or forced you to plead guilty?
Yes, sir.
All right, court accepts the defendant's plea of guilt. Mr. Manning, any objection to state's evidence?
No objection to state's evidence.
State's evidence is admitted and the court takes judicial notice of Ms. Sipes' judicial confession. Anything further from the state?
No, Your Honor.
Anything further from the defense?
Nothing from the defense, Judge.
Mr. Woodwalk, if you can give me the evidence, please.
Yes, Your Honor. On the date in question, the highway patrol pulls over a car that is being driven by Ms. Sipes' co-defendant because the license plate comes back to a different make and model and color of vehicle. Both this defendant and the co-defendant immediately exit the vehicle, and Ms. Sipes states that she has to take her dog out to walk. The co-defendant admits that both used meth the night before. He is asked if there is anything illegal in the car, and he states there shouldn't be and gives consent to search. Both defendants are patted down for officer safety, and Ms. Sipes has 0.61 grams of meth wrapped in a baggie in her back pocket. There is additionally a large amount of meth found in the vehicle that the co-defendant claims ownership of. That case, I believe, is still pending.
Thank you, Mr. Woodwalk. Any objections, Mr. Manning?
No objections.
All right, then based on the evidence presented to the court finds that there is sufficient evidence to convict Ms. Sipes of this offense. The court will follow the plea agreement and the recommendation of the state. Court hereby defers a finding of guilt, places Ms. Sipes on 3 years deferred adjudication, orders her to pay a $2,500 fine, $180 restitution, $290 court costs, and $605 in reimbursement fees. Ms. Sipes, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'll have you step over to Deputy Everett. He's going to take your fingerprint, and then Ms. Burns will give you more information about probation.
Thank you.
I believe that's all for you, Mr. Manning. Is that correct?
That is correct, Judge. I appreciate the patience afforded me today. That was much appreciated. I got an update just a little while ago. Everybody's home, safe and sound.
Good. I was about to ask. They told me right before we came back in that she had not discharged, so she's discharged at home.
She's discharging at home, slept the